to Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program, as we tell you, has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better place to decide how to protect yourself, your family, and your business. We continue to provide information and resources that will help you decide whether you need or want to contact a lawyer. Perhaps will help you to determine that you can actually handle some issues yourself. If you do need additional professional counsel, you'll be better prepared, and as a result, so will the professional you select. Either way, you'll save time, money, and hopefully achieve the best possible results. We continue to welcome and thank David Bazar, Attorney Bazar from the Bazar and Associates Law Firm in East Providence, for providing us with their information, their insights, and their perspectives in each of our sessions. In our last session, we started to speak about personal injury, so we're going to pick up on that a bit more today, and workers' compensation. As always, we try to give you a little bit of an overview, basics, some tips to help prepare you, whether you are going to have a claim or you are in a position to defend yourself against one. There's so many factors to consider before you decide you want to bring legal action, even possibly go to court. So we have real cases, some frivolous cases that you need to think about, and some new problems that arise in our ever-changing world of work. That environment causes some issues. Think telecommuting. So what do you need to do? What do you need to know to ensure that your claims have the best, highest possible potential for success, and what you should expect on both sides of that coin? So one question that comes up, David, in all the research I've done, I can't tell you that I understand why someone would say that it is advisable for someone before bringing a lawsuit to check with a bankruptcy attorney. Did we touch on this even a bit last time?
No.
Why would someone need to contact a bankruptcy attorney before they bring a lawsuit? What is that about?
I wouldn't know what they were talking about unless the person who is thinking of bringing the lawsuit is already filing or about to file bankruptcy.
Then it would make sense.
Yeah. If you're not insolvent and you're not going to file bankruptcy and there's no bankruptcy on the horizon and you haven't filed, then there's no need to speak to a bankruptcy attorney. But if you are going to file bankruptcy and you have a personal injury claim, which then would be considered an asset, that asset becomes the property of the bankruptcy trustee when you file, and your rights to recover are limited by what you're entitled to get of your assets back, if any, and what exemptions may or may not apply. So that might be the reason.
Or could it be something along the lines of, gee, I'm not sure I have a worthwhile personal injury claim, but I'm skating on thin ice because if I don't have some compensation, I'm essentially going to go bankrupt, and maybe I need to see if I protect my house in case I can't work or do anything else. Would that make sense for someone to do that?
Well, again, if there's a potential bankruptcy, whether or not you have a claim, then of course it makes perfect sense to speak to the bankruptcy attorney, explain to the bankruptcy attorney the claim that you might have, all of the assets, in fact, that you have and all of your liabilities, and the bankruptcy attorney then can give you some advice. You know, there are some personal injury exemptions that can be claimed in bankruptcy that would protect a portion of what you might recover so that it can come back to you. But again, that's a bankruptcy question, and that's best left to a bankruptcy attorney. But it can impact on whether or not you're going to be able to recover any of the money that you would get from the claim if you file bankruptcy from the personal injury case.
Interesting perspective. So there are common types of personal injury claims. We started to speak about them last week. I guess most people quickly identify with what's a vehicle accident, an automobile accident. We talked a little bit about medical malpractice, the slip and fall, and apparently premises liability is a very big issue because it's complex. As we've talked about a couple of scenarios, what do you say to either a homeowner or an employer? How can they possibly insure against all possible accidents and slips and falls? Is there any reasonable, what do you say to your clients about that, other than get a lot of insurance?
Well, get a lot of insurance.
Okay.
So
That's
after
easy.
you get past that, I guess the biggest issues are, for a homeowner, it's just maintenance of your property, and so slip and falls or premises liability on a residential property, those, usually might come with if you don't maintain your property well, so that someone's walking into your house or in your house and on stairs or on the floor, and there's problems with how it's maintained and there's an injury as a result of that. So maintenance is, of course, very important. You see it a lot with people walking in and out with snow removal and that type of thing. So you've got to be careful with how you do that.
So when you start to talk to someone, whether it's the homeowner or the employer, about things, when we talk about personal injury, it's usually about negligence. So the connection is, if I didn't shovel off my driveway or my steps, that's negligence, not just maintenance. So those kinds of things might seem a no-brainer, if you will, but it seems that so many cases can be considered frivolous because you couldn't anticipate. How do you go through the process of determining whether there really shouldn't have been that banana peel on the floor?
Right.
We understand that.
So when you say employee, you might be really referencing at that point commercial owners,
yes.
People in business to
Yes.
have retail sales on their property, supermarkets, that type of thing.
Yes, or service business too.
Right,
Could be.
any commercial
Yes.
business where someone's going to be expected to be on your property, because when you start getting into premises liability and those types of things, you then sort of have some other differentiations that you need to think about and talk about too, which are what we would call trespassers, people who don't belong on the property in any event, licensees, people who are invited onto the property, or invitees, people you expect and want on your property. So they fall into different categories, and at different times in Rhode Island, different Supreme Court rulings, there are some differentiations, and then there are not some differentiations, and then there may be some differentiations again. So we have to think about those types of things too. Why is the person on the property? And so you talk about negligence. So this all flows back to negligence, because to bring a claim for someone who got injured is a negligence claim. So it really goes to what duty is owed to that person who's on your property. And in different instances, the trespasser may be owed no duty or very little duty, maybe a duty not to create a hazard that would hurt the trespasser, versus a licensee or an invitee, someone you expect or want on your property, where there's a duty to maintain and not to create some negligent type of thing, such as a defective stairway where they might get hurt.
So suppose someone was soliciting a homeowner. Someone was soliciting a business. They weren't the invited guest. They don't go there routinely. Something happens. What happens to their potential claim against you if you're the homeowner or the business owner?
So two things. They probably are not a trespasser unless there's a sign that says no soliciting.
Okay. But if it did say that, you
Well,
might
you
have
could at
out?
least make that argument.
Okay.
We told you at the very front of the door, if you're coming in to solicit, don't come. There's no soliciting, so you might make an argument they're a trespasser. But
Okay.
whether they are or aren't, it's whether or not there was a duty that you owed to them that was violated. So if you breach the duty and that breach has led to an injury, you may have a negligence claim, which that may fall a little bit into what you were calling frivolous or not frivolous claims, depending on what the alleged duty that was breached is.
So a while ago, there was a suit brought by a woman at McDonald's. The coffee was too hot, and she did end up getting some payback on that in punitive damages, as I understand, because apparently she wasn't the only one who had had these kinds of claims, and they had been ignored. So that gave the lawyer a reason to hold them more than accountable because they ignored them. But back to the idea of negligence, I understand that it varies state to state. Is that something that, say, you as an attorney, you'd have to be very careful of if you were, never mind, approached by someone in this state versus someone who came from the Midwest? Is there a great deal of variance that means that we need to be aware of that and confer with lawyers in various states because of it? Is it wide varying?
Right, and so it's not so much necessarily the analysis of a negligence claim, but all of the things that wrap around that, what kind of coverage there is, what kind of statute of limitation there is. So an attorney practicing in Rhode Island shouldn't be handling a Wisconsin negligence case if they're not licensed to practice in Wisconsin. So whether you know the rules or not, you're authorized to practice law in Rhode Island or Massachusetts or both if you are. That's what you should be doing, not practicing negligent cases in Wisconsin. And you see advertisers oftentimes will talk about, they're a nationwide law firm and they're
Yes.
trolling for, class action suits or
Yes.
that type of thing. But they often will, in the bottom in the fine print, say, not licensed to practice in whatever, Rhode Island, but we affiliate with attorneys in that state who are, something like that. In any event, the answer to, I got to go back to something else you raised, which was the coffee case.
Okay.
So it really wasn't a punitive damages situation. It was a large award because of the amount of damages that woman suffered with the severity of the burns that she had.
Yes.
And the negligence in that case was quite clear. And if there maybe is any punitive action that might have been included in it, it was because the temperature that the coffee was sold at was so hot. And McDonald's knew that their containers would not hold that correctly and cause these injuries, and the injuries were so severe that they were liable for that. But on top of that, they were also, there was testimony that they did it because they knew they would sell more. And it was to make more money, and that's why they were doing it. And so that all factored into that award.
So I guess there were some, there were appeals and the rest, but initially, when this woman had brought suit, she was asking for $20,000, and they came back with $800 in response. If that isn't a beg for a suit, I don't know
Right.
what is. I don't know, maybe if they had offered her $10,000, maybe they might not have pressed onward, but certainly to hear that it ended up being $160,000 for her injuries alone, as you pointed out, and then $2.7 million in punitive damages for having
Yeah.
neglected the fact
Well-
that there were 700 other people, including
Right,
kids.
because it was the way they were doing business and how they were selling more, and that testimony was that, well, they didn't ignored the facts because they could make more profit. That would have been that part of it. But the injury itself was more. I don't know, and it's been a long time since I looked at that case. If the
Third degree burns.
Yeah, there were severe injuries. If the $20,000 that they had asked for initially was the medical bills, which it might have been.
Sounds
So,
right.
Yeah.
But third degree burns, hospitalization, skin grafts.
Yeah.
I'm sure there was lost work and on and on and on.
Extremely painful.
Painful.
So if it was in the hundreds of thousands of dollars, I think that would have been a low award for her injury.
Good point. So speaking to the issue about Michigan or whatever, when someone has a
I was
suit,
in Wisconsin.
Wisconsin, Michigan, what happens when someone has to determine what state they should be filing a claim in? They live in Rhode Island, it happened in Michigan, it happened in Wisconsin. The business was in Wisconsin if it was against somebody in a business. How does one determine that? Do you try to talk to two different lawyers and find out where
Well,
the better case is? How
No,
does that work?
Not really,
I
because
know.
there's a
Go ahead.
conflict of laws that's applied, an analysis to say which state has the most interest, and therefore the law of that state applies, and that type of thing. But the conflict of laws analysis is not exactly what the issue is in determining where you can file. So if you are injured in an accident in Michigan, if that's what you want to use, and you live in Rhode Island, and the defendant that injured you is also found in Rhode Island, whether they do business in Rhode Island or whatever, you can then file in Rhode Island even if the accident happened in Michigan, because there's jurisdiction over you, jurisdiction over the defendant if they do business here. And Rhode Island can apply the laws under a conflict of laws analysis that should apply from Michigan where the accident happened. And I see those cases happen a lot where you have like a nationwide chain, say a Marriott or Stop and Shop or something like that, that does business in Rhode Island. Rhode Island is the home state for where the plaintiff lives, and the accident may have happened in a Marriott in another state or in a Stop and Shop or whatever, nationwide company is found somewhere else but does business in Rhode Island.
Does it make sense, David, that the person who's injured is more likely to want to have in hopes that there will be jurisdiction in the state in which they live, because while you're preparing a case or while somebody might need to speak to someone in another state, the day-to-day practical events that are going on, wouldn't it make sense that they need to be and want to be in Rhode Island? Or
It would.
its home state?
It would. And if you're going to bring a lawsuit for an injury that happened in Michigan, and it has to be brought in Michigan because that's where the defendant is, you're going to be expected by the Michigan court to go out there for trial. So you're going to be expected to go out for deposition, for whatever other pretrial issues may come up. So you're going to have to travel if you bring the suit in Michigan, because that's the only place you can bring it. So it is more convenient if you can bring it in your home state, if that's Rhode Island or Massachusetts.
Okay. Now, we've mostly been talking about what would be a bona fide case, but I'm sure at times someone comes in and maybe they're just hoping they're going to have a PI case. What do you do when you detect that a case really is frivolous or not likely to be corroborated or whatever? What do you say to people?
Yeah.
How do you handle it, David?
So it might not be frivolous even. It might just be a case that doesn't have enough value for an attorney to get involved in. We always talk about damages, and you could be rear-ended and go to an emergency room, and that's it, and you're fine. And it's really not a case that an attorney is going to want to spend his or her time on. It's not necessarily frivolous in the sense that there is liability, but it's frivolous maybe in the sense that there aren't any damages or very much damages at all, and it's probably not worthwhile for an attorney to pursue. So we'll tell the client that up front, and oftentimes send a letter, depending, if a case had been open in the anticipation that there might be treatment, but then the client doesn't treat, we send a letter, what we call a disengagement letter, saying, thank you for coming in and reviewing the case. At this point in time, it's not worthwhile to pursue. Of course, you're free to consult with another attorney.
You say that.
Oh,
you
yeah.
would say that.
Yep, and remind them that there's a statute of limitations, which is a time by which the case either has to be settled or a suit brought, or else they'll be forever barred from bringing the suit in the future.
Okay. We started to talk last week, too, about the personal injury and workers' compensation and what would be the combination case. There are differences in the right to sue and who is sued and who has some negligence. Can you explain what some of the differences are about the right to sue? And
Sure. So,
maybe you should please, excuse me, but workers' compensation, basically, what is that?
That's what I was going to start
Yes.
with. So if you get hurt while you're at work in the course of your business doing something for your employer, and you can't work as a result of that for a period of time, you can bring a workers' compensation claim. The workers' compensation claim will only pay you for a percentage of your wages and your medical bills. And if you have loss of use or disfigurement in Rhode Island, you get a payment for those. In Mass, it depends where the disfigurement is, whether you'll get compensation for that. But so workers' compensation was designed in the Industrial Revolution days to provide a quick remedy to people who get hurt at work, and in exchange for paying them quickly, the employer who got hurt gave up the right to bring a common law action or negligence suit against his or her employee for personal injury, which would include all the other things you might get in a personal injury case, including pain and suffering. So that was the trade-off. Quick remedy, get your wages covered because people couldn't afford to go for a long period of time without income. So we made this deal back in those days to say, you get your compensation quickly, it's just your wages, and you're not going to be out of pocket without income coming in for a long period of time.
Sounds like a very nice thing to provide for people so that there's not loss. Is it true that when there's workers' comp, you don't really have to have anyone at fault?
Yeah.
An accident happened, that's it. But with personal injury, there has to be somebody at fault.
And so that's part of the trade-off. You don't have to prove, like you would at a common law negligence type of case, that your employer did something wrong, that they were negligent in how they had you do your job, or how many employees they had assist you in lifting things or anything. You got hurt, it was in the course of your employment, you would get recovery for your lost wages for that period of time when you're unable to work. That was the theory.
Okay, so if someone has an accident and it's not at work, they think about calling a lawyer. Maybe there's a suit, maybe there isn't. If there's a workers' compensation situation, or someone is injured at work, do they still need to have a lawyer?
They should.
Because?
Because there's a lot of things that go into the paperwork and what you're entitled to, and you don't pay usually an attorney out of pocket to represent you in a workers' compensation case. The insurance company pays. Unless the case is settled, then you pay a percentage like you would do in any settlement, but you're not out of pocket. And that's an important thing, because you're at a time in your life where you don't have your income coming in. You don't really maybe have the resources or the funds to pay for an attorney out of pocket. So it's set up so that you can have an attorney. What are some of the things that you need to look at? Well, you get paid based on your average weekly wage. So are those calculated correctly so that your workers' compensation rate, so to speak, what you're going to get paid based on for your benefits, is paid correctly? There is a document that needs to get filed. So if you get hurt and you're out of work for 6 or 7 weeks, but it looks like it's going to be longer, and the workers' compensation insurance company didn't file in Rhode Island what's called a memorandum of agreement, that means that they've accepted your injury, or in Massachusetts, an accepted case. In Rhode Island, after 10 weeks, 11 weeks, up until 13 weeks, they can just stop paying you.
Stop?
Stop, without going to court. If you have a memorandum of agreement, which what is an attorney will check to make sure that's been filed for you, then they can't stop paying you without going to court and having the court allow them to stop paying you.
So workers' comp gets money into your pocket right away, but then you decide...
It's supposed to be right away.
It's supposed to, okay.
It doesn't quite work that, but it's a whole lot faster than
personal
injury.
But if someone starts to collect workers' compensation, but you've determined that there was gross negligence of some kind, you can't go after personal injury, and if you can, there's something about liens that happen on injury awards. So go over that little prospect. That's quite an interesting scenario.
Yeah, so we call those third-party cases, and it doesn't have to be gross negligence. If there is negligence on the part of somebody who is not your employer or co-employee that caused your injury, you can go back after that person to recover your personal injury damages, which includes the pain and suffering and other types of things that are also included in workers' comp, and that's where the lien comes in.
Okay.
So if you recover in the third-party claim against the person whose negligence was responsible for causing your injury, then out of your recovery, the workers' compensation insurance company who paid you your workers' compensation benefits is reimbursed.
I read a percentage of 2/3. Is that reasonable? Is that ballpark, or does it vary?
If you're reading in Rhode Island, then you've just about got it correct.
Okay, but that varies state to state?
Yep, Massachusetts has a different formula that goes in, but in Rhode Island, the statute sets up a ratio, and the interesting thing, which I discovered very early in my career, is that that ratio is just about 2/3 of the recovery, and that's to compensate you, the injured person, for the attorney's fee that gets paid, usually 1/3 of what it is that was being collected. So the insurance company, workers' comp, is being benefited by your bringing the action, so they have to contribute their share, the ratio, of the of the personal injury fee that the attorney is collecting, so that it's not a hit to you.
Got it.
And the reason they have to get paid back is so it's not a double dip
hit
by you.
Thank you for explaining what seems to be a pretty complex idea. Good.
It is complex, but it's pretty simple.
Thank you for that explanation. Frequently asked question, apparently, is people who are working and then out on workers' comp, what happens to their vacation and their sick leave?
Yeah, so it's an interesting question. It's a frequently answered question.
Okay.
And while you're on workers' comp and you're not using your sick time and those types of things, you're supposed to have those preserved for you. personal injury, you may have to use some of those, and that is part of what we then want to put into your damages to say that that should get paid back to you.
Okay, what about whatever your employer-employee relationship is when you have health insurance and dental coverage? What happens to that, those premiums?
Yeah. So in different states it's different. In Rhode
Okay.
Island there's some carry of that over so that you continue to get covered. And it's an interesting thing. Our statute actually provided much more protection than COBRA. So somewhere along the way someone decided, well, we don't have to provide as much coverage as Rhode Island says because federal law rules, and now you have to pick up COBRA after a certain period of time. But there is in the statute some protection for your medical and dental and other benefits while you're out on comp.
Good to know. In the brief amount of time we have left, what an interesting issue. How do you protect yourself from the telecommuter workers' compensation claim? Many people are in the gig economy. They work from home. Oops, I had a workers' comp issue. I spilled the hot coffee on me. It was while I was working. How would you know that as an employer? What is it? How do you defend against that? How does that work, David?
It raises a lot of interesting questions, but it's not a whole lot different than let me think of one, say the visiting nurse who is going from one job to the next.
Okay.
Is she between this job and that job and the accident happens and therefore it's workers' comp, or was she on what we might call a detour and frolic? She went to go get a nice coffee
on the way.
and maybe pick something up at home. And now, so it's a factual driven analysis, and it really has to do with where they were, what they were doing, and how you can prove or not prove what type of work they were engaged in at the time.
So in an example, someone's working out of their home, they tripped over the dog on way to the printer that they were working to get a piece of paper from the printer for their job. Well, you could have tripped over your dog any other time, yes, but if I weren't in a hurry because I needed to get that piece of paper for my employer, it wouldn't have happened. I would have seen the dog. These seem to present impossible cases.
They actually present some very interesting fact patterns that the workers' compensation judges might enjoy hearing as a difference rather than the things that they hear every day. So it will be very fact-driven, and it will be based on what can be proved and how it happened and all of that.
Does this mean that now in the gig economy that employers have the onus on them to spell out very clearly what you can and can't do, what your coffee break time could be, because they fell at 9:30 and they weren't supposed to be on coffee break anyway, and I mean, are those things going to become an issue going forward?
It would be, it could be, and there might be some things you can put in, but it's really hard to know and regulate and you're not there. So is there a witness there? Probably not, unless one of those cameras is watching what you're doing.
The nanny cam.
Right.
It's very interesting. Of all of the workers' compensation cases, this was one that looks like it's going to have some heat going forward.
Yeah.
Well, we thank you for tuning in to The Law Matters, because as we tell you, the law matters to you. Stay with us for the next segment.